Hello, it's Phillip Taylor speaking from Richmond Green Chambers. I'm talking about an area of the law of contract which is always confusing to very many people. It's all about what we call exclusion clauses. They're sometimes given other names like exemption clauses or whatever, but we know them basically as exclusion clauses. And there's a book out about it, which is actually a good one. It's this one here. You can see the actual book in front of me. There's a picture of it over there. It's called Exclusion Clauses and Unfair Contract Terms. It's by Sweet and Maxwell, and it's a 9th edition now by Richard Lawson. The book itself is quite interesting. It's again set out very much in the way of the Sweet and Maxwell publications. You've got a huge amount of detail, a lot of footnotes at the bottom, and you've got a huge amount of data concerning the legislation, both the Acts of Parliament and the regulations themselves. And you've got various parts to the actual book itself, and at the back of the book you've got a whole range of detailed information in the appendices. I'll leave it just there, and you can see a copy of what the book itself looks like. Now, the title I've given the reviews, which are going to appear in the journals and on the internet, is, I've said, the modern ambit and application of the contract clause, because that's the aim that Mr. Lawson is attempting to achieve here. And as an afterthought, I've said, or make sure you check out the fine print, because that's what this is about. And you'll know probably that there are many publications, Which Magazine, Consumers Association, a whole range of organisations, and a lot of stuff now on the internet about the legislation. So let me start off by saying, isn't it too often the way? And that is that the way exclusion and limitation clauses are so frequently discovered in the so-called fine print of contracts, because they are the terms which are judged sometimes to be unfair according to a number of criteria. Often the criteria do not fit the aspirations, of course, of your client. In this close examination by Mr. Lawson of exclusion clauses and unfair contract terms, he actually is an independent consultant in marketing law, Mr. Lawson, and what he does is he reviews and analyses in this 9th edition the judicial view of what I've described as the ambit and application of the two leading pieces of legislation in this area. That's the primary legislation, the Unfair Contract Terms Act, and the UCTT regulations, in other words, the Unfair Terms in Consumer Contract Regulations. And you'll recall they were in 1999, so obviously they're celebrating 10 years this year. Essentially, this little red book here provides practical guidance and ample illustration for practitioners, and that's who it's aimed at, of this crucial area of contract law, and it's an area that many people don't understand. The judiciary, fortunately, generally do, but a lot of other people don't. What the book does, it considers firstly how the courts have interpreted exclusion and limitation clauses, and that's obviously very important. Then it looks at how Parliament enacts the separate set of controls that they've deemed are appropriate. So you've got in this book the full coverage and therefore the benefit of the case law in this area, and includes the following list, which I'll just read out. It's advice on how to draft exclusion clauses which are actually lawful, valid and effective, always important. Coverage of both commercial and consumer style contracts. Scrutiny of void and ineffective exclusion clauses. An examination of exclusion clauses which are deemed to be illegal, an assessment of what is known as the reasonableness test, always the backbone, if you like, of the common law, with reference to the vast amount of case law that we have in precedent, and an analysis of the fairness test and how this test has developed in recent cases. Now, the new material in the 9th edition includes an explanation of criminal offences which have been created in the Consumer Protection from Unfair Trading Regulations 2008. Again, more regulation which hasn't actually been debated in Parliament. Obviously the author indicates here that it may turn out to have what he says as the greatest impact on exclusion clauses, even though it's early days, because this book came out in October 2008. And so far we haven't got much in the way of precedents which have emerged. There is one school of thought on these regulations which questions the precision with which they've been drafted, and it's feared will inevitably give rise to endless wrangling in the courts. Of course, this is the problem with quite a lot of the regulations that we've got. They don't go through the whole of the primary legislation process. Now, of topical interest to both ourselves as practitioners and to the public at large who deal with these types of clause, there are references in the new edition to case law on the fairness of bank charges. Now, when the book came out, and I've been involved in some of these cases, an action had been brought by the Office of Fair Trading, and as a result there have been various issues which have raised, obviously, in various levels of court. So the OFT took as a test case Abbey to the Queen's Bench Division. In fact, it was the Commercial Court, Mr. Justice Andrew Smith, and they were looking really at disputed terms which could be construed to be fair and reasonable, together with a fresh analysis of how various sectors of business are actually being treated when the test of reasonableness is in issue. And this, of course, is a popular examination question come the exams for you guys who are doing degrees and so on. Also, the case law sheds additional light on what counts as onerous or unusual terms, which are also considered. Now, I say all of that because clearly the OFT Abbey case was heard in 2008, and again, while this edition was just coming on the presses, we were beginning to hear in the Court of Appeal the next stage of that case, and I can say that as at the 26th, I think it was, of February, certainly the end of February 2009, reported in the Times Law Reports on the 3rd of March 2009, is the Court of Appeal decision, where Abbey actually appealed against Mr. Justice Andrew Smith's judgment in certain parts. It was a declaratory judgment in the Commercial Court. What has happened is the Court of Appeal has held that the OFT can investigate the fairness, reasonableness of bank charges, and that could have a very substantial effect, obviously, for all the banking institutions, notwithstanding the fact that the banks are going through the greatest upheaval since the 1930s at the moment with the economic downturn. So there's a great deal of material in this area of law which impacts on ordinary people, customers in the banks and so on, with current accounts and events, and it's interesting and practical to see this volume coming forward at this time, because it's going to provide much food for thought, and I think it's a wonderful book for you if you're doing contract law, commercial law, and you're looking at this stuff, because it's the sort of thing the examiners love, and you get brownie points for mentioning this. So thank you, Richard Lawson and Sweet and Maxwell. Bye bye.